made, dated, and signed by the members of the Professional Practice and Conduct Committee conducting the inquiry. C. The documents produced as exhibits before the Professional Practice and Conduct Committee shall be marked, dated, and initialed by the chairperson and shall be attached to the file of the inquiry. And D. In the absence of any party duly notified to attend the inquiry, the matter which is the subject of the complaint may be decided by the Professional Practice and Conduct Committee ex parte. 56. Evidence before the Professional Practice and Conduct Committee. The Professional Practice and Conduct Committee may take evidence on oath or affirmation for the purpose of the inquiry. 56. Attendance at inquiry. The Professional Practice and Conduct Committee may, for the purpose of an inquiry, by notice in writing, direct any person specified in subsection 2 to attend at the time and place specified in the notice for the purposes of the inquiry. 2. Directions under subsection 1 may be given to A. the complainant, B. the respondent, C. any other person who, in the opinion of the Professional Practice and the Conduct Committee, is likely to be able to provide information relevant to the inquiry or whose presence is, in the opinion of the Professional Practice and Conduct Committee, likely to be conducive to settlement of the matter, to which the complaint relates. 3. The Professional Practice and the Conduct Committee may, in a notice under subsection 1, require the person to produce any document specified in the notice. 4. A person served with a notice under subsection 3 shall not be compelled to give evidence or produce any document which the person would not be compelled to give evidence or produce in any proceedings before a court. 5. The Professional Practice and the Conduct Committee shall give each party to an inquiry reasonable opportunity to call witnesses, to give evidence, examine and cross-examine witnesses, and make submissions to the Professional Practice and Conduct Committee.
Counsel, I didn't quite understand clause 56(4). A person served with a notice. A person served with a notice shall not be compelled to give evidence. Can you just explain that?
Chair, I think basically what it's supposed to say, maybe it needs a little rewording, but I think what it's supposed to say is that if evidence would not be compelled to be given in a court of law, then that evidence should similarly not be compelled to be given before the PBCJ. But maybe it needs to be reworded, and it's a little clumsy to the end. There will be a rewording, Mrs. Gordon-Jones, towards the end of 4.
The drafter indicated that she will have a revisit of the clause to see if it is in keeping with the other provisions that would normally be said similar in other legislation.
Mr. Foreman has his hand up. Go ahead, Mr. Foreman.
Yes, thank you, Chair. I just want to clarify which of these documents we're looking at. The provision that I see says a person served with a notice under subsection 3 shall not be compelled to give evidence or produce any document which the person would not be compelled to give. Okay, so it's the additional to give evidence in the wording that is causing a problem?
Yes, it's a bit clumsy.
The provision speaks. Sorry, I didn't hear that.
No, we're saying that is exactly what we're saying. Is a little
Okay.
clumsily worded, so maybe it just needs a redraft.
Right. Okay. Sorry. Thank you for the clarification.
Madam Chair, to you, is there provision for representation by the teacher against whom allegations have been made? It's not clear from what was read that the person is entitled to representation. And secondly, I'm a bit concerned about just stating that the matter may be heard ex parte without laying some conditions under which it can be heard ex parte. And those will be two of the concerns I have in respect to the clause just read.
Chair, I think maybe his first concern can be addressed by stating that it is provided for, but he probably preempted Mrs. Gordon-Jones because she's coming to it. So it is captured at subclause 5, or that's 7. 57. So it is there, Senator. But in relation to the ex parte, Mrs. Gordon-Jones can probably address that.
So, Chair, the provision says, in the absence of any party duly notified to attend the inquiry. So, if the person has been given notice and decide not to show, but the must also note too that it says may be decided. So it's a discretion of the Professional Practice and Conduct Committee as to whether they will proceed with the hearing in the absence of the person.
Thank you. Please continue.
Sorry, person or under representative? Because again, I feel I heard what Member Hamilton said, but I really believe the legislation should recognize the importance of representative, and that person has a right to be represented before any such body.
Okay, Council, please continue, and it will become clear to the member what the member is asking about.
Clause 57, right representation. A party to an inquiry may be represented by an attorney at law or any other person, or may elect to be self-represented.
Thanks, and I just want to pause here for us to accept clause 56. I'm sorry, clause 54 to 57. So confirmed?
Oh, no. I understand what you said a while ago about the right representative. But given we're talking about the teaching profession, given that they have an organization now representing them that is recognized, that any other person is broad, I accept. But some recognition of organization representing teachers or trade union, for example, Senator Gill, if you're there, should also be added to it. There are other tribunals where the representation is state it a little more broadly, because I accept any other person, but I believe we in a country which recognize collective bargaining and so forth, we should give some weight to the fact that an organization representing teacher or trade union be included.
Go ahead, Member Hamilton.
Chair,
go ahead.
The use of the words "any other person," it is wide enough to include an organization that would represent teachers. Right, so any other person would also include the association.
Yes, it's very wide.
The
Any
fear,
other person.
Chair, is that if it is that we include the union, would we be removing the any other person? Because that in and of itself would also prove a problem. Because if a teacher does not necessarily want a union to represent him or her, then that person would be restricted to either a teacher or a union rep or an attorney. And that may not necessarily be the case for that particular individual.
My proposal is not in the alternative. It is to complement what is already there. And I have already accepted that any other person is broad. But given that we're dealing with a profession that is well represented and we have respect for the collective bargaining process, I felt it would be important and useful to include without removing any other person the right of organizations representing teachers. We need to just show some respect to the
member.
Is it about respect,
please do not,
Madam Chair?
Please do not impute anything, and nobody here is showing disrespect. We are talking about a particular clause. You have agreed that the term "any other person" is very broad. And
Minister, with respect,
Mr.
I'm not
Foreman,
imputing
Mr.
any
Foreman
motive.
had
I'm not
his hand
imputing
up.
any motive. I don't know why we're so thin-skinned. Nobody's imputing any motive here. I'm simply making a proposal.
No, member, you know what you're doing. Please refrain. Please refrain. I call on Mr. Foreman.
No, I'm not refraining. I'm not imputing motive. When you
Mr.
people,
Foreman, please, your turn.
Different views. You jump to imputing motive. I'm not imputing any motive. I'm simply saying we need to include the teachers' representatives in the bill.
All right. Mr. Foreman, do you still have your hand up? Go ahead, member.
Can I just make a suggestion? Because in the normal course of establishing a grievance procedure and associating it with this particular clause in relation to the right of representation, it is normally accepted that if there is a recognized trade union, then the recognized trade union would be included in this particular clause. So a part to an inquiry may be represented by, in the first instance, their recognized trade union, an attorney at law, or any other representative that they may choose to select, rather than having it stated as any other person. So that would be my suggestion.
So can you repeat exactly what then you suggest, member?
So I'm suggesting that a party to an inquiry may be represented by, in the first instance, the recognized trade union, because it is known that they have a recognized trade union, an attorney at law, or any other representative that they may wish to select.
We can't discount the fact that the person should be able to represent themselves.
No, if you notice, I never include that because you should not be representing yourself.
Yeah, but people have a choice.
SG?
Thank you, Chair. I hope I can be heard. I do have a little bit of a difficulty with the use of the word recognized trade union, because who recognizes a trade union? Can I suggest that there is precedent for this? So if we are given time, we can just look for something that's used in another act. Because the whole thing about this recognition, there are times when, so for instance, when you're nominating persons to a committee or a board, for instance, you would then indicate who would be the person. So you would say, if you're referring to a specific type of entity, you would indicate who would be the person to recognize that entity if they aren't established in law. So this whole thing about recognized trade union, that's a little unclear. And we have a normal, usual formulation that we could perhaps just use, if that's okay.
Yes, thank you so much. We will make a note.
I have no problem, SG, in looking at it. The Labor Relations and Industrial Dispute Act is one such piece of legislation that is useful. So, and it doesn't say recognized trade union. So I have no problem with that. But the recognition in the bill of the existence of teachers' representative is important to me. And I make that point without imputing any motive to anybody. But the reality is that those who are in the field knows how this thing goes. And I'm not residing from the position I advance. With respect to the AG's, to SG's position, I think we should go and look formulation. We don't need to reinvent the wheel here.
All right, so members, I put clauses 54, 55, 56, subject to the amendment in 4. And
sorry, Chair.
Go ahead,
Chair?
SG, go ahead.
Yes, sorry about that. It relates, I have a concern in relation to clause 54D. So 54D is saying, in the absence of any party duly notified to attend the inquiry, the matter, which is the subject of the complaint, may be decided by the PBCJ ex parte. That's not a usual provision that we put in law, and there's a reason why. There are different common law rules, there are different decisions that explain how and when a matter may proceed. We're not able to list all the different variations. And so this is the reason why we don't usually put it in. We usually leave it to common law. We also would leave it to the entity, the tribunal. This PBCJ could also make their rules. The reason I have a difficulty with this is suggesting that on the first hearing, everybody is notified to attend and the PBCJ could continue. This is inconsistent with case law. Case law would say at the first hearing, it should be adjourned. And the other side should really get another opportunity to attend. So this is not taking into account all the different variations and nuances as it relates to a matter proceeding with only one party present. I would strongly recommend we remove this provision. Just because you remove it doesn't take away the power. It just means that the power now would be decided by the PBCJ in accordance and consistent with case law, as well as they could make their rules to govern their procedures, which would include matters like this.
Members?
Madam Chair, are you hearing me?
We're hearing you loud and clear.
Okay, thank you. Just to say, I support what the SG is saying. We do need to be mindful of the case law and the way things are normally done. What I would love to know is from the Ministry of Education, the legal team there, was there a particular reason they wrote it as such?
Chair, I cannot speak specifically to the reason, as the bill itself, the draft bill itself predates me, but I am aware also, though, that the provision, there's a similar provision in the education regulations, which speaks to the hearing that is conducted by the personnel committee. So I am not sure if it's a clause that was taken based on that provision.
Madam Chair, unless it is something that we don't know of, and in this case we can't act because we don't know, I was listed by the SG, only because I think we should ensure that the law as written meets with what is precedent before it. And because it was in the Education Act before doesn't mean it's the right way to go. So I would go with the advice of the SG on this matter.
And just to note too, Minister, I agree with SG's position, but also just to note that in practice, as far as I'm aware, they normally adjourn the hearing in the first hearing if the accused person does not show.
If the accused person does not show up, then what?
It's adjourned.
It's adjourned. So that assumes that the accused person is not willing to defend themselves?
No, it might be a situation where the person just could not attend.
Okay.
And so there would have been communication with the board or the school to say that not able to attend or so.
Okay.
We have a situation where upon the day of a hearing, it was adjourned because it was communicated on the day that the person won't be able to make it.
Right. That's fine. What we're trying to do is to, you see, we may have an entrenched practice. We may have an entrenched practice that would have been working. What we are trying to do is to improve it. And maybe we could take what the SG has said in terms of the case laws to guide us. Because, you know, these matters would have evolved. And case laws normally dictate changes. And we can be instructed by such. So I would take what the SG, in terms of the SG advice.
Council, Anastasia, do you want to look back at the education regulations?
I am just, yes, the regulations, 57.3 says if a person complained against fails to appear at the hearing and the committee is satisfied that notice of the hearing was given to that person in accordance with paragraph 1B, the committee may, if it sees fit, conduct the hearing in the absence of that person. My only issue in terms of not speaking to it based on what has happened, because of silence, it's always an issue because it's not expressly stated. There is always an issue in terms of what to do.
And I would agree with you, Council, because we have well over 1,000 schools. That means 1,000 boards in the system.
The only thing is, this is in relation to the PPCC, not the boards.
The PPCC, okay. Sorry.
So maybe in this instance, seeing that, as SG indicated, the PPCC may create rules for its own proceedings, then they will know, if in a situation as such, what to do. So I guess we, as SG indicated, we can delete that provision.
And we would be okay with the kind of consistency of the decision of the PPC on this score? They would look at the situation that presents itself,
right,
and decide. Okay.
Right.
Go ahead, Member Hamilton.
Chair, I was just really thinking on the provision, because I do understand the mischief, but I see the difficulty in putting this into legislation. Especially, it would be difficult based on the circumstances before the PPCC. I think maybe they should have that discretion using common law to determine whether or not they proceed with the matter. So as you indicated, on a case-by-case basis, they would make some determination. But maybe whatever regulations they put within the council to guide disciplinary matters could treat with it somewhat, rather than here.
SG, you want to come back in?
Yes, thank you very much, Chair. I heard Mrs. Gordon-Jones make a comment about silence. I have to disagree, and actually strongly disagree. Because of all the different rules you have as it relates to administrative law, we're unable to replicate all of them in a law, whether in the Act or in regs. We don't replicate most of them. We leave it to the common law to help to deal with the fairness of the process. So there are a few things that we usually generally highlight in our laws. It does not mean that because the other things are not highlighted, they don't apply. They do. And do you know why we know this? Because every time they are not applied by the relevant tribunal, we go to court, and the court will always make it clear that all of these different rules, whether or not they're replicated in statute, apply. But again, I start out by saying we're unable to replicate everything in law, and this is why we highlight a few things. The ones that we're going to highlight are not those that are so nuanced that you would know, breaking it down into subparagraphs and paragraphs of those subparagraphs, which is what I say with respect, and that's my view, that there are too many nuances as it relates to adjournments, as it relates to how you conclude a matter without one party being present. Because you see, you go to the heart of fairness when you do something like that. It's a very nuanced kind of application to that rule. Most of it can be objective, but there is still some subjectivity in it. It is best to leave those types of matters to the PPCC. Now, I know that you already have an existing rule in your regulations, and this is probably why there is some angst. First comment I'd make is the rule in the regulations is formulated differently. It talks about the relevant body being satisfied of certain things. It means it gave them some discretion and that they had to inquire into the matter. That is not replicated here. I still have concern about putting that type of provision in law. It is not something I usually see. In fact, I was quite surprised that it was actually in those regulations. And I just think that, especially because common law can develop, what you put in may tie your hands. So anytime you replicate common law and you codify it and put it in legislation, you have now fixed the position in legislation. It means that you don't move with the common law. So the common law can keep developing, and you can't, because you have to apply whatever you have put in your legislation. And for those reasons, I really, again, recommend that you remove D. Thank you, Chair.
Chair, if I may.
Before you come in, a member, the council had indicated she wanted to say
I'm sorry.
something. Yeah.
Thanks, Chair. Just to clarify something that I indicated for SG, in relation to the silence, the issue that we're having now is that when matters come for treatment under the regulations by board chair, because it is not there, they always call on the ministry as to what to do. So even though, yes, we are appreciative that there's administrative law, so they would end up calling us at the ministry to find out what procedure they must take in order, based on a particular situation. So for us as the legal mind, it is clear, but for them, they are not aware, and we have a lot of situations we are referred to the ministry for advice as to how to treat with a particular situation. So that is the issue that I was raising, SG.
And just to support council, I can see why, when we have over 1,000 boards, that every board would think differently and want to hear, because these boards are not necessarily persons with a legal background, and they don't want to make any mistakes. So that's why they'd call on the ministry. But I take your point as well, that this is one entity, and it's staffed with persons who have some legal background or legal background. Okay. All right. So members, I put to you again, Claude.
Am I going to be
sorry.
allowed to
Go ahead.
comment?
Sorry, member. Sorry. Go ahead.
Yeah. Yeah. Well, let me say that the government has a way of sending out circulars. And so circulars can be sent from the Ministry of Education to the boards, explaining some of these issues and giving guidance. On the original point, I agree with the SG. The principle of fairness is something that our courts take up regularly. And up to recently, the doctrine of Lord Mustill, I believe, in the Doody case involving prisoners and their rights, in which the doctrine of fairness has been outlined, is what guides me when I make submissions here, not imputing motive, but certainly just trying to get the committee, based on my own experience as a trade unionist practicing in this thing, to so operate that we protect the legislation, we protect the people there, and we operate in the context of the fairness doctrine. And I'm glad the SG mentioned that fairness issue. That's how I come to it. I have no ill will. I have no need to impute motive to anybody. And I'm offended when people think that because I put forward views that I'm imputing motive. I will withdraw the thing about thin skin, but I really feel strongly that, stop accusing people of imputing motive, when in fact all I'm trying to do is to insist on fairness to everybody.
You can't tell her to stop having to do that. You can't tell her that.
Please.
What I can't tell her?
You earlier on,
to stop imputing motive?
You talk about respect, and we expect that in this parliament. You were the one who introduced that concept, implying that we did not have respect, and that's what I was referring to. But let us move on. I put to the members.
Sorry, I don't know that I said that people have no respect. We may disagree on points, but I have not imputed any motive here, and I have not attempted to do it. Because when I want to do it, I'll just make it very clear. That's how I feel. I've not done so.
Okay, member, yes, I think we've sufficiently ventilated that. Let us move on. I put clause 54 to the members, accepting subject to the deletion of D. So moved.
Accepted, Chair.
So accepted. Right. Clause 55. So accepted. Clause 56, subject to amendment of 4 for a little bit of rewording to make it a little clearer. I put clause 57 will be reviewed by the SG, and so we move on to 58. Mrs. Jones.
Just to clarify, Chair, that 57 is not for the SG to review. It's for us to look at similar provisions and not to reinvent the wheel. So we look at the other provisions in other legislation and make the necessary changes.
Thank you. Okay, please carry on.
Disciplinary action, 58. Disciplinary orders, results of disciplinary inquiry. 1. Upon an inquiry conducted under Section 53, the Professional Practice and Conduct Committee may, depending on the nature or seriousness of the complaint, make any of the following decisions. A. Issue a warning to the person, B. Censor or reprimand the person. C. Impose such conditions on the registration, license, or authorization to teach of the person. D. Suspend the registration, license, or authorization to teach of the person. Or E. Revoke the registration, license, or authorization to teach of the person. Subclause 2. In making a decision under subsection 1, the Professional Practice and the Conduct Committee shall take into account any submissions made in accordance with the notice served under Section 56. 3. The Professional Practice and the Conduct Committee shall issue a report of its decision under subsection 1 to the Council. 4. Pursuant to subsection 3, upon receipt of a report from the Professional Practice and Conduct Committee, the Council shall, within 7 days of receipt of the decision, serve a written notice on the person, A. Specifying the decision that has been made, B. Specifying the reasons for making the decision, C. Specifying the date that the decision takes effect, which shall be no earlier than the date that the notice is served, and D. Specifying the period that the decision may remain in force under Section 61. 4. A copy of a notice served under subsection 3 shall also be served on any person employing the person who is the holder of a license or an authorization to teach.
I put clause 58 to the committee.
I just want a clarity on C. So C speaks to impose such conditions on the registration, license, or authorization to teach of the person. D speaks of a suspension, and E speaks of a revoke. But what could that imposition, such condition be? For example, because D and E are very clear in terms of the action.
There's a provision under the bill that speaks to the conditions that may be imposed. That's clause 30, subclause 2.
Maybe make reference to that clause. Making 58C subject to 32.
Yeah. Just for clarity.
Subject to clause 30 subclause 2, sorry.
Council? Go ahead, Member Brown.
Thank you, Chair. Is it the intention of the legislation to make the disciplinary action retroactive? It speaks to not earlier than when the notice was served. And depending on when the notice was served, it could result in some amount of retroactivity. Is that the intention? Or is it that from the date of the decision by the committee that the punishment or the penalty, if you want, would be effective?
And you're talking about C, Member Brown.
I don't have it in front. I don't have it in front of me, Senator Gill, but
Yeah, it says
that might very well be.
C says, specify the date that the decision takes effect, which shall be no earlier than the date that the notice is served.
That is correct. That is the clause I'm speaking of.
Based on the reading, it's saying that the effective date shall not be earlier than the date of the notice. So it can be later, but not earlier than when the person receives the notice. So it does not have a retroactive effect.
No. It must have, if the notice is given a month before, and it could be longer.
No, it's after.
Then, sir, go ahead.
It's after the decision it's after the decision is made.
The effective date, as I understand it, can be prior to the date the decision was made. That's why I'm asking the question about retroactivity. It may not be the intent.
No, that's
but as it is written there now, it could have that impact, and that's why I'm raising the question. Not out of imputing motive, but just out of clarifying the legislation.
Let me reread what 4C says. It says, it says that the serve a written notice on the person specifying the date that the decision takes effect, which shall be no earlier than the date that the notice is served. So the decision, the effective date of the decision cannot be earlier than the date of the decision, of the notice. And so it does not have a retroactive effect.
No, but if the notice was given a week ago, just for argument's sake, let's use a short period, then a decision could have effect no earlier than the date of notice. But if the date of notice was a week ago, or did a month ago, whenever, that allows for a retroactive thing. I prefer to hear a word which says,
how I read it,
shall have effect no earlier than when the decision was made by the committee.
But how I read it, that the council shall serve the notice within 7 days. And then now it flows with the specification of all these things. That's how I read it. So I'm reading it in conjunction with when the council would serve the notice of the 7 days, or within the 7 days.
SG, go ahead, please.
Thanks. I think maybe just to clarify, and especially for Member Brown, it's not the date of the notice, it's the date the notice is served. So the decision takes effect when the person actually gets the notice, or a prospective date thereafter. So I think
and the question is, if the notice is not the same day as it, we don't expect it to be the same day of the decision.
It would be after the decision, but remember.
So let us make that clear is what I'm asking for, to make it clear.
No, it is. That's what I'm saying. I don't, because you don't have it in front of you, Member Brown. So what is said, what I'm reading says that the notice would be served within 7 days of the decision, which means that the decision could be taken today and you have 7 days from today to serve the notice.
All right, I appreciate that. Thank you, I appreciate that.
And then it's when the notice is actually served that it would either take decision on that day of service or some later day.
And it is the notice after the decision has been taken.
Yes,
that
correct.
We're talking about here.
That is,
I appreciate
because
that.
there is another notice in the clause. That notice relates to another one, but the notice here is in relation. So the chapeau of 4 spoke of this notice, and then it is this notice that is being referred to in the paragraphs, sub-paragraphs below.
And not the notice of the hearing.
No, that's the notice in 57, because that is referred to in 54. So that's referred to in 2 sub-paragraphs above. That's in 58.2. That refers to a different notice. 58.4 is yet another notice.
That clarifies it for me, and I want us, and the committee record would show that we're talking about two different notices, and that's fine.
No, the committee was specifically speaking to one notice.
Sorry, Member Gale, I think the issue is that 58 refers to 2 different notices. So 58.2 refers to a notice under 57, whereas 58.4 is looking at a different notice, the notice that is given after the decision is taken.
But it is still clear, SG, because we're relating to
yes, so that's what I was saying, that it is on the paper. But remember that I don't think Member Brown has the paper in front of him.
For those of us who have the paper in front of us and reading it, is likely to interpret it in the way that you advised, SG.
Okay, thank you.
I'm very comfortable with that explanation.
Thank you, members. Thank you. So I put clause 58 subject to.
So did we, before that, did we sort out
subject
how
to
we're
C?
going to apply C?
Yeah. Subject to 30.
No, I never get the confirmation. No, she said it. We never get a confirmation from.
Okay.
Chair, If we may, Mr. Foreman had some suggested wording for the amendment to 58(1)(c). Can he be allowed to speak?
Sure, absolutely.
All right, thank you, Chair. From the discussion, my understanding is that the committee is comfortable with C, clearly indicating that the conditions that the PPCC can decide to impose are those which the council itself could have imposed on the registration of the teacher or instructor. So in accordance with clause 30 subsection 2. So I suppose additional language to link the decision there to the conditions that can apply in 30 subsection 2 might cure the concern that was raised.
So Mr. Foreman, can you just suggest the wording that would support that, please?
Member, my skill set is limited to recommending the idea. I defer to the CBC's office.
I hear you, but I don't believe you. But anyhow,
details of the
I hear you about the skill set, but I don't believe you. But anyhow.
By the way, Member Brown, could you check your email? We're sending you a soft copy of the document, so you have it.
Thank you very much. I'll check it.
Without imputing motive, Member Brown.
Can we just add in at the end in accordance with 32? Subsection 2, right? 30 subsection 2.
Sorry, member, if I may, Chair, what we were trying to explain is that we would prefer words that would say that the PPCC can impose conditions that the council can impose under 30 sub 2. Would prefer that kind of language. Because it's not really in accordance with and it's not subject to. What we're saying is the power that is given to the council in 32, that's the same power we want the PPCC to be able to have and be able to execute. So using the language like in accordance with doesn't really do that. Because they're not acting in accordance with 32. We're talking about a power that exists in 32 that we want them to have.
So, SG, what you would be doing is just giving the PPC the authority.
Yes, to impose the same kind of conditions that the council can impose under section 30 sub 2, clause 30 sub 2.
All right, fine, I can live with that.
All right, so I put again clause 58 subject to amendments in 1C. So confirmed?
Yes, Chair.
Thank you. All right, we move on to clause 59.
Just to clarify, Chair, there is no change for 58(4)(c) in terms of the date of the notice, the date that the notice is served. There's no change.
Okay, no change.
And just to clarify also, when you say that reasons would be given to the teacher, does that exclude the report from the committee, or is it no allowing for the teacher council to do a summary? Because I believe the full report ought to be given to the accused.
To which clause are you referring, member?
I'm referring to the clause which speaks to reasons being given. And I'm wanting to be certain that the reasons given by the committee would be contained in the committee's report, and that the teacher would not be given but an extract of the report of the finding of that committee, but the entire report of that committee.
Member Brown, my trade union colleague, I see what you're seeking to do. And I understand. I don't know, though, if we could put that in the legislation. And I'm thinking of a tribunal award provides the reasons in a detailed format. So is it that you're asking for the reasons to be done in that detailed format as an award? Like an award?
Not necessarily, but if a committee meets and makes a recommendation to the Teachers' Council, and they're going to convey that to the accused worker, the accused teacher, then the teacher should be given the copy of the full report, not an extract from it. And so I believe it is 50, let me see, this is 50, is it 3B of, is it 50, what it is here? 57, I believe it is. Just trying to look it up on my phone in the fine print.
58.
4B.
4B. It says specifying the reasons for making the decision.
Yeah, that's the clause I'm talking about. So my question is the teacher to be given the full report, which I support, or is the teacher to be given an extract of the report? You see, in what we're doing, we have not suspended the right to seek judicial review. And so the issue of the notes of the full report would be important if somebody wishes to seek judicial review.
That's why I say I know exactly where you're going, because in the event that one would be seeking judicial review, then they would be privy to the detailed report that that would surround the decision.
Correct. And so
is that question
that's an important issue that I think we need to.
Yeah, I know it is. I know it is, because we would have in many instances, if we are going to appeal a matter, would want to have full clarity in terms of what would have contained in the decision leading up to any judgment.
All right, SG has her hand up. Go ahead, SG.
Thank you, Chair. So I think the issue The issue here is the fact that the law requires the PPCC to prepare a report. Now, generally, a lot of times we don't have that requirement in law. I'm not saying it's unusual, but it's not always there. The issue then is, if they are required to produce a report, why is that report not going to be shared with all the parties? And I think that's the question that needs to be answered. Why would the council then be required to reduce that report to some sort of summary, summarized version, and then release the summarized version to the parties? I think that's the question you need to answer, and I think you'll find the answer will help to guide your decision. My own view is that if the PPCC is required under law to produce a report, that report should be shared to all parties.
SG, what that would require then is maybe an addition to, what's it, 54.4 to be more expansive.
Well, perhaps not, but
let me give somewhere else?
No. I agree with 54.4. I don't know if it needs to be more expansive. I just think it's a reorganization, meaning I think it should be clear that the report should detail the reasons for the decision. I think that's where that whole thing about the reasons for the decision and so on, all of that would relate to what should be in the report.
So that would be in the report, and that would inform the council.
You know that is an inference. Sorry, but remember, that's an inference you're making. Look back at what's on the paper.
No, I'm not talking about what's on the paper now, I'm just based on what you would have said in terms of the sequence of events. Yeah?
Yes.
A report from the PPC to be submitted to the council.
Yes.
The council would then make a decision providing the reasons as a consequence of the report. So what you're in fact saying, what I understand you to be saying, is that if the council is going to get a report, then they aggrieve all parties involved should have been privy to the report.
Sorry though, member, I thought it's the PPCC who's taking the decision.
Yes, SG, that's it.
Yeah, man, it is the it is the PPCC, that's it, that is making the decision.
Right.
And then now sending the decision to the council.
Right.
And the council would have the report.
And notify the person.
And the council would then notify. What Member Brown is asking is, and what you may have alluded to, is that report to be privy to all parties involved.
Well, can I be allowed to just clarify my comment? I really think it would be better form, since we are requiring the report to be done by the PPCC, and since we are all agreed it's the PPCC who is taking the decision, what the law should really say is the PPCC is going to do a report. The report must specify the reasons for making the decision. The report should indicate the date the decision takes effect. Because I think those are the decisions of the PPCC and not the council. All the council is doing is it's a conduit. It's a secretariat. So we shouldn't be putting any of this on the council. It should be the PPCC. And it should be clear when you read the provision that these are the steps that are to be taken by the PPCC. And we should also be very clear what is to be contained in the report. A big part of what should be contained in the report is the reasons for the decision. So it would have the decision and it would have the reasons for the decision. Right now, the way it is set out, I don't think that is as clear as, I think we're inferring some of that. And I don't see why we are sticking the secretariat in the middle of it to reduce a report, including the decision and the reasons for the decision. They are reducing it to some sort of summary. I'm not sure why we are doing that.
Chair, I agree with the proposal of the SG.
Yeah, I agree as well.
Council?
Yes, Chair, I agree with SG's position. So it would need to be reworded to indicate that the report should have those information.
All right, so I put again clause 58, subject to amendments in 58.1c and in 58.1, 58.4 A, B, C, D.
But so, Chair, based on what SG just said, 58.4b would not be necessary. I think what could be included is the council making the report available or providing a copy of the report to the relevant parties.
I agree with you, Member Hamilton, and again, I'm motivated by fairness.
Okay, we get it, Member Brown. Thank you. All right, so subject to those amendments, clause 58, subject to amending 58.1c and 4b, or that entire
It's
ABC?
3 and 4.
3 and 4. Right, subject to amendments, clause 3 and 4. I put this to the members for confirmation. So confirmed, thanks. We move on to clause 59.
Suspension or revocation of registration, license, or authorization to teach. 59. 1. Where a registered teacher, a licensed teacher, or an instructor has been charged with a disqualifying offense, the council may suspend the registration, license, or authorization to teach, as the case may be, held by the person until the determination of the matter. 2. Where it is proved to the council by a certificate of conviction from the registrar of the Supreme Court or the clerk of the parish court or from an equivalent officer from a court of competent jurisdiction outside of Jamaica that a registered teacher, a licensed teacher, or an instructor has been convicted of a disqualifying offense, the council shall, as soon as possible and without further inquiry, revoke the registration, license, or authorization to teach, as the case may be, held by the person. 3.
I'm sorry, go ahead, Mr. Foreman, you have a hand up?
Yes, thank you, Minister. My comment is in relation to subclause 1 of this clause, the reference to until the determination of the matter. I'm recommending that that language be more specified. My impression of the bill is, we'll get to clause 60 shortly, but clause 60 speaks to the effect of suspension of registration, license, or authorization to teach. And part of what it does is in sub 61B speaks of suspension being enforced until the charge that forms the grounds for the suspension is dealt with in any of the following ways, and then it lists the ways in which the charge, that the criminal charge against a person, was decided, to include the charge being withdrawn, person dies, charge being dismissed, person is discharged by the court, person is acquitted of the offense, etc. I think if the intention was that until determination of the matter means these specific situations, that the clause in 59.1 should be linked to those conditions. Until the determination of the matter might give rise to questions of interpretation in practice, which we could avoid.
I had those concerns, and I think that they're legitimate. It can be cured by an addition to the clause after determination in accordance with the one below.
Member Brown, when you say the one below, sorry, what do you mean? Clause 2? Clause 2?
Is it 61 with the...
Oh, 61.
For the courts and so forth?
Okay. All right.
A disqualifying offense is serious. Why leave it to may suspend? So a disqualifying offense means an offense for which the penalty is a term of imprisonment of 2 years or more. So consider that being serious in nature. Why the council may suspend. So it says in 59.1, where a registered teacher, a licensed teacher and instructor has been charged with a disqualifying offense, the council may. So that leaves the council to make a judgment in relation to what is a disqualifying offense. I believe that may put a great degree of burden on the council to make that determination whether you suspend or not. Whether it's until the matter is resolved or not, you know, the assumption in my mind is that the person would be charged with a disqualifying offense in the first instance. And then now, because of that charge, the council is placed with the burden to determine if you suspend or not.
Senator Gill, there's a presumption of innocence if somebody is charged.
I agree with that, you know.
And that hasn't been resolved. So I am for the flexibility in the may. There may be representation made before the council before they suspend. And in fact, as I understand the Charter of Rights, such a person would be entitled to have representation before being suspended or so forth. And those representations may put a different light and things. So I prefer the council or the committee taking the decision rather than Parliament predetermining that you shall, because I think that's where you're going.
Well, no, that's not where I'm going. Where I'm going, cool. And what I'm seeking to clarify. So you have posited the reasons for the council to make a determination. In this case, would it be left up to the council just making a determination? On what basis?
As I said, Senator, the 16.2 of the Charter of Rights speaks to people being allowed to make representation before adverse decisions are made against them. And whatever we do here, we can supersede and overrule the Constitution. And so issue is, if you say shall be suspended, then it makes no sense to hear the matter. But a hearing has to take place in a sense if the person so desire. And it is for that reason I am supporting the keeping of the may, because it doesn't mandate the outcome. It certainly says you must listen, and then you may find good reasons. For example, there might have been a decision taken abroad which is not yet before the council. The council only here, John Brown was charged in Florida, was found guilty in Florida, and the result of an appeal or so forth hasn't been brought before the committee. And it is for that reason the committee may wish to exercise its discretion before rushing to shall. And I think that's really the alternative to the may. It is the shall. And I would stick with the may. So that's my position.
If I may, Chair, I mean, I think I would want to stick with the may as well to allow due process, because it outlines down to number 4, 58.4, what should take place. And so once the person, whatever information they receive, I think due process should be allowed before the person is dismissed.
Carry on, Council.
Chair, in terms of clause 59, the words in square brackets, until the determination of the matter, are proposing that based on the fact that 60 treats with the effect of the suspension, we could remove those words until the determination of the matter. So 59.1 would indicate that they may suspend, and then 60 now will indicate if the suspension is taken. If the suspension is done, then what will happen? Right.
All right, please carry on, Council.
So are we taking the proposal?
Yeah, sorry, Minister,
Okay,
Chair.
Go ahead. Sorry, Mr. Foreman.
Yeah, I'd be fine with that, because it would mean that 59 and 60 would have to be read together. But if you're going to add those additional words, you need a clarification. But I think removing it wouldn't do injustice. So I agree.
Sorry, did you say injustice?
He's agreeing
to... Right, it would not undermine what I think the intention was, which is that 59 empowers the council to suspend, and then 60 tells you what happens after the suspension, right? To include the circumstances when the suspension ends and that sort of a thing.
(59.3) Where the council suspends or revokes the registration, license, or authorization to teach of a teacher or an instructor, as the case may be, the council shall forthwith notify the employer of the teacher or instructor, requiring the employer to take all necessary steps to ensure that the teacher or instructor ceases to teach for the period that the suspension or revocation remains in force. 4. Where upon the conduct of an inquiry into a complaint by the board of a public educational institution or other employer of a licensed teacher or instructor, the decision of the board of that public educational institution or of that other employer of the licensed teacher or instructor, as the case may be, includes a recommendation that the registration and license or authorization to teach should be suspended or revoked, or that a condition should be imposed on the relevant registration, license, or authorization to teach, the board of that public educational institution or the other employer of the licensed teacher or instructor shall, within 7 days of the decision, make such recommendation in writing to the council, specifying the reasons therefor. Chair, I was just reading and thinking at the same time in terms of making a recommendation to the council in terms of the suspension of the license or authorization to teach. I was just thinking whether it should be the council or the PPCC.
I'm glad you raised that, through you, Chair. I'm glad you raised that, because as you read it a while ago and as I looked at it, it appears to me that the decision is the council's, not the PCDC or whatever it is, not the Professional Conduct Committee. And so that further to the discussion we had earlier as to whose decision it is, it appears to me that the decision-making body is really the council. And if that is so, we need to make sure there's consistency as we go along in this section.
Chair, I think in a previous sitting, we indicated that there should be some direct communication with the board and the PPCC. There was, at the last sitting, we were treating with another issue in terms of the matter not being heard within the 6 months. They should, the PPCC, instead of referring it to the council, for the council to refer it to the PPCC. So in this case, 5 now read that upon receipt of a recommendation under subsection 4, the council shall refer the recommendation to the Professional Practice and Conduct Committee for a determination. So if it is that the position is for the board to have a direct relationship with the PPCC, then I think it would have to be a similar situation in this case.
But member, council, matters, I remember in prior clauses that the matters, it seemed to me that matters should all flow to the council, because I remember the passage that says, the clause that says the council would look at it, determine whether they deal with it. Not that, which clause are you talking about?
The clause which treats with the matter not being heard within a certain time, within the 6 months. Currently, 9 months under the education regulation, which says if it's not heard within that time, it will lapse. So the provision now is for the PPCC to be able to conduct an inquiry where it is not treated within 6 months, as we have changed the time from 9 to 6. But there was a discussion that there should be a direct relationship with the board and the PPCC in referring the matter to them for them to hear the matter.
Yeah, I don't know, but I prefer it to go through the council so that they have sight of it as well, rather than directly to the PPCC.
No, it's not 51.
I think how it's written here that the council they would refer it to the council and the council would refer the recommendation to the PPCC.
Chair, I may have lost track. I was trying to. We're dealing with clause what, 60?
No, 59. We're looking at 59.5. We're dealing with the matter of boards in which, if they have not heard a matter within 9 months, currently the matter falls away. And we're saying that shouldn't be the case in this new regime. It should be referred to the council, and then the council referred to the PPCC. So council was saying that she recalls that the board should be allowed to refer the matter directly to the PPCC rather than to the council and then the council to the PPCC. I prefer for it to go to the council rather than directly to the PPCC.
Yeah, I agree.
Yeah, so the council has sight of all the matters. Yeah. Council.
Very well, Chair. So it's for the committee now to decide whether these proposed provisions will be taken. I did.
So I
Just
put.
if you want me to read
59.
5. 59.5. Upon receipt of a recommendation under subsection 4, the council shall refer the recommendation to the Professional Practice and Conduct Committee for a determination.
All right, so members, I put clause.
Just to clarify, Chuichi, the council referred to the committee for determination, and does it come back to the council for their to act? In other words, does the Professional Conduct Committee have the standing to do all those things, or is it the council that have the standing to so act? Just clarifying.
And Chair, in terms of the recommendation being made by the board to the council, in terms of notifying the minister and the teacher under the education regulations 57.6, there would need to be allowance for the board to move beyond that 14 days that is currently specified, to allow for the matter to be treated with in terms of the whether to revoke or suspend the license. Seeing that that's a new dispensation, because 57.6 says the board shall within 14 days after it has received the report of the personnel committee give written notice containing details of its decision to the minister and the teacher. So there would need to be provision in place to treat with the situation where the board now recommends the registration or license to be suspended. So there would need to be some provisions for that.
Sure. Really thinking about these two provisions and how it flows, what Council was proposing earlier in relation to that relationship between the board and the PPCC, I kind of understand where she's coming from. Because if the board should make a recommendation or request for a particular action to be taken, if it goes to the PPCC, then the PPCC can make the recommendation, can make a determination and then make that recommendation to the council. And then the council would then inform the relevant parties, rather than it going to the council making a recommendation to the PPCC making a determination and then going back to the council. It kind of has a tidier
efficiency flow.
Yeah, for more efficiency, it would be good for that relationship to be had. And less time would be taken in these matters.
Right, I understand, but I guess I was just thinking about the circumstances in which there might be a separation, might be seen as a separation between the council and the PPCC, and the boards able to go directly to the PPCC, and then the council may say, well, I don't have sight of this matter, I don't know anything about this matter, I don't, maybe
yes, but at the end of the day, the PPCC still has to inform the council of whatever decision that they've taken. So the council would have knowledge, I presume.
Council.
Chair, just want to clarify the position of the committee in terms of the process flow here for 4 and 5.
So I believe members are saying it would make for a more efficient process for the board to report the matter directly to the PPCC, for the PPCC to make a determination and then go into council, to the council. Right. So we'd have to change 4. Council? the committee, right, is agreeing that the board would directly report the matter to the PPCC, and the PPCC would give its recommendation to the council, and then they would do the administrative work.
It is just a process flow. So the council has the authority, but the PPC is the actors. And so the board, in terms of a process flow, rather than go to the council for the council to drill down to the PPC, and then the PPC send it back to the council, the board directly goes to the PPC, the PPC makes the determination and then advise the council. That's what that would do, is just take out one leg of the bureaucracy. Because in any case, the PPC would be the actors. PPC.
I thought, sorry, through your chair, I thought the Professional Conduct Committee was a subset, was a child of the council and doesn't stand independently of the council. And while I appreciate the efficiency point and not having it comes through the board, we're opening up to 1,000 boards, the Professional Conduct Committee. No, so it's almost a free-for-all, if you wish. No coming to a central authority. And what does the Professional Conduct Committee do after? It then says to the council, we got a report from Trinityville and high school, whatever. I just pick a name, and this is our finding. You must know rubber stamp it, or you must know act on it. I want to see what is the consistency between the Professional Conduct Committee and the council. And so I'm not certain yet if I share my brother Gail.
But remember, the PPCC would not be sending a recommendation to the council to be stamped or rubber stamped. The PPCC would have made their recommendation, and then actions flow, made a decision, and the actions would follow from that. It's not
again,
a rubber
it comes
stamp
back, Minister, that the decision maker is now the council, and that's the point that was made earlier.
No,
who is the real decision
no, the
maker?
PPCC is the decision maker on these matters.
Then it doesn't make a recommendation to the council.
I should not be, I take back that word, it should be their decision to the council.
And so again I ask, in the construct of the legislation, is the PC Professional Conduct Committee, does that have more say than the council in taking decision? Because the professional body, conduct committee, can't suspend the teacher, can't warn the teacher, can't do anything, can't dismiss the teacher, can't revoke. That's a function of the council. And so we need to make sure that.
Remember, wouldn't that be the administration of the council? I mean, the PPCC makes the decision. They're the decision-making entity. They hear the case and they make a decision, and then it goes to the council for implementation. Huh?
Oh, so it's not the council taking the decision?
No, I
think we have everything wrong.
Member Brown, maybe you can go back to 58, because that's why we're doing this amendment, to give the PPCC the same authority that you're referring to just now. Because if you realize under 58, it says the Professional Practice and Conduct Committee may make any of the following decisions, and it outlines the different decisions that can be taken by the PPCC. So what we're doing is trying to give that authority to the PPCC, which you just mentioned. So that would have been cured.
Council, and that is where I have a little difficulty. Because I thought the council, we're putting in the council to take these big decisions, and instead we're now outsourcing it to 5 people, none of whom are members of the council. What is the purpose of the council then? That's a concern I have. And again, I'm raising this genuinely.
What 5 people are you referring to? Please don't be confused with the tribunal. That is a separate, yeah, but the tribunal is a separate body from the PPCC. So you have to, I'm not sure what 5 people you're referring to.
Is the professional conduct committee a subcommittee of the board? Is it the panel that is going to hear the matter?
Go ahead, Council.
Or does it line up relative to the board, to the council? Sorry, the council.
Professional Practice and Conduct Committees, it's not a subcommittee of the board or the council.
Sorry, it has been given power super the council, because I thought it was the council who appoints, the council who can revoke, but now we're transferring that power to revoke and so forth to the professional committee. Isn't there a conflict in the construct of the legislation? That's the question I'm asking. And again, I ask it for clarity.
The Professional Practice and Conduct Committee is the one responsible for the disciplinary matters. So they are the first layer of treating with the disciplinary matters and are not to be confused with the tribunal, which speaks to the 5 persons that you may have referred to. So they are the first layer.
He also wants to know what is the...
And they're appointed by the board of the council.
Right. So if you look at if you look at 14 of the first schedule, it gives that speaks to the constitution of committees. There's a reference there.
Council. All right, so council, we're on clause 59.
Sorry, before you move, just to clarify what Senator Gill is saying. As I understand it, Senator Gill, 14 of Schedule 1 of the first schedule speaks to subcommittees of the board. And so the board, which is the council, would have to approve whatever a subcommittee does?
Not in the Professional Conduct Committee, Member Brown. There's a specific indication in the schedule that the recommendation of the Professional Conduct Committee would not have to be ratified by the board. So clearly the scheme of the act is fairly clear in terms of the council gets these disciplinary complaints. And then the Professional Conduct Committee has been established as a committee of the board with some independence to conduct these inquiries and to make a decision based on the inquiries that have been conducted, and to send that decision to the council, and the council will then remit that decision, etc., etc. Clearly, if somebody feels aggrieved by the decision, then they have an ability to appeal to the tribunal. So the Professional Conduct Committee is that entity that does the investigation and the determination of the matters and reports that to the council. That's my understanding of the scheme. I think what we have been debating for a long time in this specific point is whether the board should directly bring the matter to the Professional Conduct Committee, or they should bring the matter to the council, for the council to refer the matter to the Professional Conduct Committee. It's more about efficiency flow more than anything else. I don't have a problem with the scheme as envisioned, which is where the report would go to the council, or if the time has elapsed, then the council would refer the matter to the Professional Conduct Committee. I don't believe that the boards would have to directly report to the committee, but for me, it's neither here nor there.
No, member, I think this particular point now is in relation to boards of schools that may want to refer or request or make a recommendation or request that a particular sanction be imposed on a teacher.
Yes.
And that being communicated now to either the council or the PPCC. That's where we are.
Yes, either the council refers it to the PPCC, or they just send it directly to the PPCC.
Yes.
Yeah, and I'm saying I have no difficulty with how it is that they send it to the council and it is referred. But I'm neither here nor there. I just don't know if we want to open direct channels between the board and the PPC, or those channels should come through the council.
But how do we make it efficient then? Because if the board wants to make a particular request for, maybe we need to put, because it would be the board sending to the council making the recommendation to the PPCC, the PPC making a determination, and then going back to the council to say this is our decision. Fine, but how do we make it efficient?
Do we put a time frame on it as far as once it's reported to the council, then it would have to be referred to the PPCC in a specific time to make it more efficient, if that's the route that we're going to take?
I appreciate the concern, and maybe timeframes are the answer. I'm just not sure whether laws should get so granular. But, I think we are all very concerned about how long these things take. And that is why we're trying to be as detailed as possible. I think that's our challenge.
And if we go the route as is, it would mean that we would need maybe another clause or provision there to speak to the PPCC going back to the council with the decision taken.
And if I may, I think Chair wanted the board to actually inform the committee and not go over the head, I guess, and before it's reported to the PPCC. So I'm not sure if you're more comfortable with that and to put a time frame in.
And additionally, the council will now have to notify the parties. So that would have to be included here as well. No, the the council, after the PPCC makes a determination and informs the council now will have to act on that. So they will have to send out notices.
Member Hamilton, what does it go back to the provisions that are already there in relation to once the PPC makes a decision and sends it to the council? In other words, all this is saying is that when the board makes a recommendation and it is sent to the council is to refer that recommendation to the PPCC. And then would it fall into all the other provisions that we have regarding when a matter is sent to the PPCC? So they would do the determination and then they would send the decision to the council and the council would have to provide a notice within 7 days, etc., etc.
I think it must be clearly stated.
In other words, I don't know if we need additional provisions based on what we have already.
Or references made to what we have already, but I think something has to be said because it can't just be left like this. Because the interpretation, so I'm looking at it. If a board wants to recommend something to the PPCC or to the council, the board can have that as a part of their decision making for whatever hearing that they may have presided over. Now, if the PPCC does not think that they should act, that information must now be sent back to the council for some kind of notice to be sent. As it is now, it just says that the PPCC will make a determination. It is kind of left. Is either we're going to link it back to what we have before without us having to go back through all of those, but we can't just leave it as is, in my opinion. And it would have to speak specifically to the board or the institution. Some information or notification have to be sent back to that particular institution. What we have now is in relation to just parties. So that would have to be included.
You have two different situations, right, at the board level where the board can actively refer a matter with a council or PPC, and you have the situation in which the board has not. This is specific.
This particular provision is specific where a board already goes through a disciplinary hearing and has come to a decision. When a part of that decision touches and concerns the council making a decision, that is where this particular provision comes in. For the board now to make a recommendation or a request that the council intervenes. So in this situation, the council would have to go back to the board to say, we agree or we don't agree or we've taken this position or we are not. So it couldn't just be left to what has been done before in relation to the council.
Yeah, I understand what Member Hamilton is saying, that this is a different scheme. So the scheme that is outlined before is specific in relation to sections 52 and reports that come in regarding this. This scheme now, where is a report from a board to say that they want a license revoked, suspended, or whatever, that this is now saying under 59 that once the board suggests that has to be referred to the committee. So I get what Member Hamilton is saying. We would also have to outline what happens in relation to the determination of this matter. So if the above sections are to apply in the same manner, then we would have to say that. So take the point, Member Hamilton.
All right, thank you for that clarification, Member Green and Hamilton.
Chair, we will examine the provisions and provide the committee with the further proposed clauses in relation to this matter.
All right, because it seems that it's going to be extensive, we will wait to get those the additional changes.
Just to clarify, are we going to the council first, then to the PBCJ? Or am I making this?
Yes, to the council.
Very well.
To the council first. All right, so we won't confirm this clause just yet. We'll await council coming back to us with a more expanded set of provisions. All right.
Maybe, Chairman, this is a convenient point, given that the chamber is going to be needed for a big speech in less than 2 hours' time for us to.
There's a big speech? That never came to our attention.
I know, you will get it later on.
For what? We can delay that.
And given that
this really sounds like more.
We'll excuse you.
We can suspend that one.
We'll excuse you.
You let some of us have to pick up children who are not in school today. So maybe it's a convenient time to take the break. I don't know. I'm just raising that.
So Member Brown, we'll excuse you from the proceedings.
We should press on until 2 o'clock.
All right. We'll excuse you, Member Brown.
I was never asking for excuse. I just wondering it was a convenient time at 12:13, given all the events of today, to break. I don't know what is the intent, how long we intend to go for.
12:30.
Oh, that's fine.
All right, Clause 60.
Clause 60, effect of suspension of registration, license, or authorization to teach. 61. Where a suspension relates to a registered teacher, licensed teacher, or instructor who has been charged with a disqualifying offense, the suspension remains in force until the earlier of the following occurs. A, the council cancels the suspension, or B, the charge that forms the grounds for the suspension is dealt with in any of the following ways. 1, the charge is withdrawn, or the prosecution for the offense charged is discontinued. 2, the person dies without the charge having been determined. 3, the charge is dismissed by a court. 4, the person is discharged by a court following committal proceedings. 5, the person is acquitted of the offense by a court. Or 6, the registration, license, or grant of an authorization to teach of the person is revoked because the person was found guilty of a disqualifying offense by a court. 2, for the purposes of this act, a person whose registration, license, or authorization to teach is suspended is deemed not to be registered, licensed, or authorized to teach for the period of that suspension. 3, a person whose registration, license, or authorization to teach is suspended shall not start or continue to practice as a teacher or instructor in a school or other educational setting to which this act applies. 4. At the end of a suspension under this act, the person whose registration, license, or authorization to teach was suspended shall be reinstated as a registered teacher, licensed teacher, or instructor, as the case may be, and is considered to be registered, licensed, or authorized to teach on the same conditions that were previously imposed on the registration, license, or authorization to teach, unless otherwise determined by the council. 5. Where a registered teacher, a licensed teacher, or an instructor has been discharged or acquitted of a disqualifying offense for which the registration, license, or authorization to teach of such person was suspended, that person shall be reinstated as a registered teacher, licensed teacher, or instructor, as the case may be, and shall be reimbursed as prescribed for the period of suspension, and is considered to be registered, licensed, or authorized to teach on the same conditions that were previously imposed on the registration, license, or authorization to teach.
Is that a square bracket?
A little.
In council in 5, is that a decision to be made about that? Shall be
no, I need some clarification, Chairman, through you.
Okay.
There's no provision for somebody to surrender their license in the process. And is that something somebody an allegation is made against somebody? See if they cover resignation, somebody surrendering the license. Is that something that we cater for? And secondly, where somebody is acquitted, we speak to reimburse. What is not clear is who will reimburse. So, for example, in the public school, would that be reimbursed by the state or for other employer, since we use that term? Let's say the College of Portmore, that doesn't exist, but let's say the College of Portmore exists and employ a teacher.
Remember, you have to go to clause 62 to get all of that.
All right, so you're saying it's there.
It's
as
in
to
62.
Who will pay the reimbursement?
Yes.
And what about the surrendering? Is that there in 62 too?
Surrendering.
Under clause 61, in terms of the revocation, if the license is revoked, 61.4 indicates that the person shall surrender the license to the council within 7 days. That's in the case of a revocation.
Yeah, but before the revocation, if I says I'm not contesting this thing, I'm surrendering my license. What provision exists for that?
Member Brown, what you're speaking of is a voluntary surrendering.
Yes, that is correct. The equivalent of a resignation. But it's more than a resignation. It's saying, take back your license. I don't need it. You don't need to go through a disciplinary procedure. Is there provisions for that? And should there be?
So what you're saying, in my mind, is, for argument's sake, an individual may decide that I don't want to go through this trauma of a disciplinary proceedings. And so, as a result, I am willing to give up practice. And so, I am voluntarily surrendering my license. I will part company, and that closed the matter. I think that's what
does it close the matter if that takes place? What I'm asking.
That's what you're asking. If it closed the matter.
Yeah. Yeah.
So I do intend to contest and go through what might be this possible drama of disciplinary proceedings, which I personally and emotionally could not handle. So I'm willing to walk away. And thus walking away offers me the opportunity to surrender my license, and the matter is null and void. In other words, in our world, someone who is under a charge of a transgression of employment can seek to resign and move on. That's what I believe you are suggesting.
You're correct, and a teacher just texts me to say, and given the low wages that teachers are being offered, it might suit me to move on. But forget that last part. But
yeah,
so member, I don't see the relevance of you introducing that. No, come on, member.
Yeah, resist.
Let's focus here.
I believe you're texting.
Lambert,
I believe you're texting yourself.
Lambert wouldn't be Lambert if he didn't go there.
We can ignore it. I don't know why you're jumping on that. But anyway, that's the reality though. The low wage is the factor. But
if
what
you're
I'm
ignoring it,
asking,
why
my
say
substantive thing, the substantive part is, are we catering for resignations here or surrender of the license? That's the substantive part. And you know, Fly Green knows that if somebody says 7 up to us now, we take it as a joke. So you know.
No, but I don't run the 7 up joke because it's too heart-wrenching. And when you see, for example...
You're not at one on that slide.
Yes, but when you see, for example, the significant increase that we are trying to give our teachers, appreciated how difficult it is to maneuver the classroom space, right? I would suggest that you stick to the matter at hand. I think all of us here want to see the best. I'm
glad you're giving it legs. I'm glad you're giving it legs.
I'm
glad you're the minister giving the little joke on me.
Because you said
I'm happy for that, but I don't agree that the teachers are getting a substantive increase.
But what is joke for you is dead for somebody else. So let us get back to the matter at hand.
Thank you, Member Green. Go ahead, Counsel.
Madam Chair, just to remind the committee that Clause 49 gives a person the opportunity to be deregistered. You can notify the council that you would like your name to be taken from the register. The council, it says, 49.1 says the council shall remove the name and particulars of a person from a register or the roll of instructors if the council receives a notice in writing in the prescribed form, along with the license or authorization to teach. And similarly, well, if we are considering to include a provision that says that the person can voluntarily surrender his or her license, and we have to contemplate 49.
And 49 for the purpose of stopping the inquiry. Is there a connection there? Because if I send to the council, and the council is not even aware that I am before the professional conduct committee, that hearing continues by them or could continue by them. So I'm not sure if it fits into, if it allows or what we're saying here.
So are you saying that if somebody voluntarily want their license to be suspended while they're going through a hearing, that hearing should cease, should stop, should come to an end? Is that what you're saying?
I mean, that's a gap that he may want to incorporate, which I wouldn't agree with personally, because if there is a particular issue to be heard and a teacher voluntarily removes themselves from the registration and licensing process, if that should allow the proceedings to end, then what would prevent that person from reapplying for registration and licensing, but still having this matter that has been unheard out there in abeyance? How would that be treated? The issue would not have been resolved.
It boils down to what information the council will have, because the council then decide if somebody reapplies. That should be a red flag to the council that something happened along the way. Let me check that before. And this is why
But the matter wouldn't have been ventilated, and you, as a union person, will say that this person is innocent until proven guilty.
Yeah, I understand that. And so I'm saying, if the council has the information, which it would not have under the current scheme now, that there's an hearing that is set up, an inquiry that is set up, but he resigns from the council and he reapplies to the council will be put on guard. There'll be a red flag to say, why did he resign 2 or 3 years ago or 2 or 3 months ago and is reapplying? And it begs for information that goes to the professional conduct committee to also go to the council. So the council would have in its database that there was a charge against the person.
But what can they do with that charge?
With that charge? They could simply say, given the fact that there's a charge outstanding against you, we are not going to grant you another license. I'm not sure if you heard that. That given that there's a charge that was outstanding against you and you resign, we're not going to grant you another license. It is now up to the council to decide if it wants to grant it. And invariably, one would think the council would say, given that something was pending and you didn't complete it, we're not going to give you. You're not a fit and proper person.
All right, members, please go on mic if you want your comments to be.
I'm just saying, Chair, that in a situation like that, I think a determination must be made by the council. So somebody voluntarily removing themselves from registration or licensing shouldn't stop a process, a disciplinary process. That's in my opinion, because a decision should still be made at the end of that disciplinary hearing.
I agree.
Chair, I agree. I
Yes.
don't think we should waste time for the person to maybe go and reapply once again and go through the whole process. I think a determination should be made, no matter if the person falls out or not. The process should continue.
If somebody who is no longer a teacher will surrender their license, you can revoke that person's license?
No, that's not what we're saying. We're just saying
But that would be the effect
the
of it.
process should come. We should complete the process so that you know what the decision is. So that's on record, right? Yes. All right, members, what I hear is that even if the person asked for their license to be removed, that the process should still continue and a decision should be on record.
I just beg to differ and state my opposition to that, because the committee remove himself from the list, and therefore there's no need for us to take a decision. If the ultimate thing that we have as a committee is to recommend the revocation or to effect the revocation. So I just wish to separate myself from that decision, but the majority of the committee can always hold that view.
Voluntary removal from the process would not preclude somebody coming back. When a decision is taken by the council, that prevents that person from coming back. So I see it.
All right.
I understand, but I disagree, because the information would be with the council and for the council to decide.
All right, yes, let's continue.
But Chair, in
We
terms
agree,
of the,
yeah.
in terms of the decision, clause 43 indicates how the council may decide an application, whether it's an application for registration, which would in this case be registration if the person voluntarily decides to be removed from the register. It does not provide for the council to consider a situation as such. So if it is that the applicant has satisfied the requirements, then the council would have to grant the registration.
Unless we put into it that one of the conditions is whether or not the person is fit and proper relative to allegations made in the past against a person.
So, Chair, is the decision to include a provision to indicate that if the person has voluntarily decided to remove himself from the role, the matter is to continue?
Yes, that's the agreement of members.
That's the agreement of the majority.
All right, so let's complete clause 61.
Chair, I'm so sorry. Can you just repeat the decision of the committee, the last decision?
That in the case in which you have someone who's going through the process, the disciplinary process, that if they voluntarily ask for revocation of their license, that the matter should still be heard so that there can be a decision on record for that person.
Okay, but is it that the revocation, so the person asked it for, well, I don't know, do they have to get
voluntary
permission?
revocation, voluntary
Like,
revocation.
do they actually have to get permission for that? I thought if somebody wants to withdraw from the rule, they could. And the issue I then have is if the person is no longer on the roll, what is the jurisdiction of the council? Because I thought the jurisdiction of the council is to deal with persons on the roll.
All right, so SG, let's say there's a matter regarding an abuse of a child that comes before the council or the PPCC, and that teacher says, I want to voluntarily suspend, I remove my standing, do we just stop in the middle of the process, or do we continue? That's what we're trying to decide.
I understand. And what I'm saying, though, is, number one, I don't know if they have to get your permission to come off the roll. That's the first thing. So if the person doesn't need your permission, they could just come off the roll. I'm now asking, if that is so, what would be the jurisdiction of the PPCC, noting that the PPCC is applying disciplinary sanctions, not criminal sanctions? So it suggests to me something like an abuse would be something you report to the police. You could have no the criminal jurisdiction taking over. I'm still querying the jurisdiction of the council to deal with someone who is not on the roll.
So, Chair, just to come in on this point, again, I don't think this is something that one requires any form of sort of legislation on. The reality is that if a teacher has been brought before the council and the teacher resigns and is no longer part of the profession, then the council would have no standing to bring any further action against the teacher. What would have to happen internally is that a notation be made on the file of that person, so that if that person applies again, then that can be taken into account. But we could not proceed with a disciplinary hearing where the person has already distanced themselves from the profession. I don't see how we could.
You are correct, Member Green. But I think what would have triggered the extent of this debate was when Member Brown indicated if the person wishes to resume or to reapply. Now, the fact that the person would have...
Senator Gill, no, not Senator Brown who raised that. Member Hamilton raised that.
No, Member Brown sent us down this path that I'm not...
Come on, you send us down this rabbit hole.
Yeah, if somebody wants to resign from the profession and he sent us down, I'm trying to be fair to him and not to ascribe motive. Right?
No, don't try the Manchester United compatriot.
If somebody wants to remove themselves from the profession and give up their license, then they could not be stopped. So if again in another profession you decide not to get your practicing certificate, then that is that. Now, again, if you have a criminal matter that doesn't go away, right? If there are disciplinary proceedings that would require you to participate in them, and you're no longer in the profession, then you will no longer be subject to jurisdiction. Clearly, the council would have to internally ensure that somebody could not use this to fetter a disciplinary process and then try to re-emerge in the classroom. And that is what Member Hamilton's valid concern is about. And that would have to be something the council would have to take into account, that you couldn't just resign, walk away from a disciplinary process, and then reappear to become a classroom teacher without that process having been concluded. So I'm not sure whether that is something that we need to legislate for, but that is something that the council definitely internally would have to put a system in place that where a process was not concluded, say, for example, somebody migrated, right, and the process was not concluded and then returns, then, it would be a condition precedent that matter would have to be brought to resolution before they be able to get the license, which I don't think should be difficult, seeing that now we have the council, which would treat with all of these matters.
So you're agreeing with me?
This is
I don't agree with you at all.
You're agreeing with me, whether you want to deny it or not. You're agreeing with me.
I don't believe
essentially what I'm saying, if somebody takes himself away from the teaching profession, you can't continue the hearing.
Yeah, but you know,
persons
Brown, as a long-term unionist, sometimes I wonder why you raise this, because you know, this is not a matter that needs any detailed discussion.
But
right?
the discussion in the committee shows
if you are representing a man before a panel and the man migrates, right? You have to go and indicate to the panel that he's no longer there and the matter is.
If it's migration, you can hear the matter ex parte.
Okay, thank you.
Which allow, but in this case, it is somebody specifically saying, I hand in my license, I'm no longer a member of the teaching profession. You can't, as it's been proposed here, to continue the hearing, because the person is no longer a member of the profession, which is what you have admitted to, and which
so
is what I was saying.
The PPCC would no longer have any standing in relation to that matter. But that's not the issue. The issue is whether or not later on down the road, that individual will seek to resurface.
Then there must be notation on the file.
And so the council would have to make a determination whether or not it's accepting. You see, in this case, it's not a situation where you have resigned from employer A and decide to be re-employed to employer B. It's the same employer you're seeking to come back to in this case.
No, it's not even the employer, Kavan. It is about the council.
Yeah, but
takes decisions.
Remember, Brown, let us know, the PPC, I would suggest, would still file a report on the matter, depending on the stage that the matter has reached.
We're agreeing on that. Agreeing on that.
So again, and that report will be a part of the file of the person who is
John Brown, of Tom Stroke.
Yeah,
we're agreeing on that. But you can't continue the hearing is the point I believe the SG has made. You have made, I have made, Kavan has made.
But I don't know why it came up as a point in the first place. I wonder.
No, it came up because I'm saying, what happens if this happens?
But you're asking questions you don't answer for.
No, it is clear from this committee that the answer wasn't clear. It is now clear, and I'm happy that answer will show the clarity.
Remember, Hamilton went to another point, which is a valid point, which is about if the person tries to re-emerge. Anyway, sorry about my interventions without seeking permission.
All right,
Chair.
No problem. Go ahead, Counsel.
In terms of Clause 43 speaks to how the Council may decide, and at 43(1)(a)(2), it speaks to the applicant meeting the eligibility requirements for registration under Section 27. Section 27, or Clause 27, has at 27G, meets any other prescribed requirements for registration as a teacher. So I am asking SG's intervention as to whether we could prescribe under regulation a situation as such that was being discussed in terms of the teacher re-emerging. So that would come under the eligibility requirement for registration. SG, through you, Chair.
Yeah, thank you. And a nice and good question. But I think I would have to, myself and Mr. Foreman would look at it and we could advise. And I'm saying this because we would have to find the thing and look at it, the provision, and I'm noting the time.
All right, thank you so much. We'll pause here then, because it seems as if this is a matter that needs to come back to us. All right, so we'll move to any other business. All right, the date of the next meeting is Wednesday, March 15 at 2 p.m. Wednesday, March 15 at 2 p.m. Please make a note of that. Let me thank everyone for being here today and for the discussion. I look forward to seeing you. We're hoping that we can begin to conclude on this. Thank you so much. This meeting, the hybrid meeting of the Joint Select Committee on the Jamaican Teaching Council Act 2022 is hereby adjourned. Thank you.
$1 trillion. That's how much the government plans to spend this fiscal year. It's your